Thank you so much, Balonza. My name is Winnie Onyango. I'm an advocate.
Welcome to Know Your Law. Now, today we want to talk about or to tackle the issue of mediation. Mediation, most people will hear mediation and remember Kofi Annan, the mediator who mediated Kibaki and former Prime Minister Raila Odinga and mediated, and we had a government that included a Prime Minister position that was not there constitutionally. That was a mediation occurrence that people can't remember. But do you know you can have your cases solved amicably via mediation? You can have a mediator, and now today that is what I want us to talk about. Winnie, our wakili here will take us through it, and the first question I will ask, what is mediation?
Wow. Yes, as you said, mediation is what actually helped us through the 2007 post-election violence. So mediation is one of the many dispute resolution avenues that we have, though most people are not aware of it. And it is the process where two people who have a dispute can get a third party who is neutral. This third party is the mediator. And the third party takes them through, or rather oversees the process of them resolving their dispute.
Okay.
Yes.
Okay. So how does mediation work?
So mediation, we have two main types of mediation. Okay. We have court-annexed mediation, and then we have private mediation.
Okay.
Court-annexed mediation is invoked by courts. This is where parties went for litigation, and then the courts, after going through the files and screening them, they come to a conclusion that these files are best placed or referred to mediation. Then they get a court-annexed mediator to go through the files and handle the files through mediation. Okay? So the parties in that matter will be referred back to mediation. When we go to private mediation, on the other hand, this is where two people were out there who are just having their issues, decide to get a certified mediator. Okay? And the mediator can handle the case at hand, either physically or online, okay? And take these parties through resolving their dispute, yes, to the end.
Okay.
Yeah.
So that means once you get into the process of, before you even get to there,
yes,
who is allowed to be a mediator? Can I just go and say I will mediate?
Okay. Yeah, nice question. So for one to be a mediator, you have to go through a training, okay? You have to go through a training which normally takes 40 to 50 hours of training. Once you go there, you finish your training, you are given a certificate and you become a certified mediator.
Okay.
And upon being a certified mediator, you're now allowed to handle cases. But allow me to say that before one starts handling cases as a mediator, it is normally recommended that you go through mentorship, because we have institutions out here that offer mentorship for mediators out there, you know, just so you have a grasp of what happens on the ground, you know, how cases are, before you can handle real cases of, you know, people having real disputes. And one of such institutions is the Dispute Resolution Hub.
Okay.
So this is an institution that, one, handles mediation cases, and two, they offer mentorship to mediators out there who've just finished their course and want to get now into that field.
Okay.
Yes.
And once you go through the 50 hours or 40 or 50 hours of training, who can train? Must you be a lawyer before you start training, or anybody can take the training?
Anybody can take the training of a mediator. You need not be a lawyer for you to be a mediator. Yes, and there are also institutions that offer mediation training. Yes, and there are several of them. You can just go online and check them out. get to know their charges, get to know everything that is required for you to enroll to undertake the training. Yes.
What are the advantages of mediation? Why should I go for mediation and not just go the litigation or the court way?
Nice. So mediation, as compared to litigation, if you look at the two, you'll come to realize that one, with litigation, which requires going to court, you will take more time from the time your matter is started to the finished time as compared to mediation. Okay, so mediation ends faster. That is a first advantage. Two, when it comes to costs, okay, mediation is cost effective. It's more affordable as compared to litigation. Okay, and also to add that mediation is a private process. Okay, so the parties get to have that privacy of their matters. So even if the matter is sensitive, they can handle it privately. As you know, if you look at litigation, where once your matter goes to court, any member of the public is allowed to access the courtrooms and listen to your matter. Yes.
Okay, so let's go to the court annexed mediation.
Yes.
Must one, how does it come about? Because if it's from the court, does that mean you had a case in court that was trying to be litigated?
Yes.
Is it just that the court just decided to give you that way to choose?
So here we have a mediator who is certified. Okay. They go and enroll with the judiciary, okay? And they become a court-annexed mediator. Then we have the cases that are before the courts, okay? So these cases, when they go to the courts, they go through screening.
Yeah,
okay? And through that screening process, the courts will decide that these ones should be referred to mediation, okay? Upon being referred to mediation, the court-annexed mediators that we have are now given files to handle, okay? So you get that maybe parties might have gone to court to get their dispute resolved through litigation, but then the courts give them an avenue to resolve their matter through mediation, which is faster, by the way. And if that works, then their matter gets solved, you know. But if should it not work, then they are referred back to court, okay, and the matter continues with litigation to the end.
Okay.
Yes.
So now that we've already understood, you can either decide to either go. You can either be forced by the court to have a mediator solve your case, or you go through privately. Who chooses the mediator? Now, when we talk of private mediation, the parties choose the mediator, okay? You can either choose, we have advocates, of course, who've done mediation, who are mediators. We've had also mediators who normally are based with religious institutions, and we also have mediators who just practice on their own. So parties can decide to just, you know, through either referral or, you know, just checking online, get a mediator and then agree on how to go about the mediation process of their dispute, okay? But when it comes to court-annexed mediation, the court will link you up with the mediator that will handle your matter. Yes. Okay. Let's get to the developments in the mediation space, especially the court-annexed mediation rules. How much or how far has it gone?
Now that's a good development in the mediation space, because initially and for the longest time, most people have rather not gotten, you know, their matters solved through mediation, because there's an opinion out there that, you know, so what after mediation, you know, it won't bind, no one will live up to their part of the agreement, okay? But now with the mediation rules that we are having, upon the conclusion of the mediation process, Okay? Parties can decide to register their mediation agreement. This is normally registered in the mediation registry that is maybe near where the mediation took place. Okay? Once you register that mediation agreement, you are given a file. Now, it doesn't stop there. Parties can decide to go a step further and get that mediation agreement adopted as a court order. Okay? Now, what happens is if the mediation agreement is adopted as a court order, then it becomes binding to the parties. Okay? So as if should there be any party who maybe will breach their part of the agreement, then the other party can enforce that agreement against them. Yes.
Okay.
Yes.
So that's how far it has.
That is how far it has gone in helping the parties that get involved in resolving their disputes through mediation. Yes.
Are there cases that cannot be mediated upon?
Oh yes. Mostly we get like maybe government cases. Okay. And not all of them. Some of them are normally referred to. So it's mostly on case-to-case basis. Okay. And also sometimes in cases that involve fraud. Okay, because where fraud is involved, then you'd rather take it for litigation and let the courts now decide and oversee the process. Yes.
Something like, case in point, criminal offenses.
Yes.
For example, somebody stole from me, I reported them, and the case is being litigated. Is there a possibility to mediate that, or that is just for the courts?
So normally, mostly in criminal offenses, the courts will normally hear that because, let me give you, for example, you get that one has committed maybe robbery with violence. Okay. Now starting to mediate on that is normally a bit tricky. But also the criminal justice system has its own ways of solving cases. And just to digress a bit, you get that when you're dealing with the criminal justice system, a party may decide to withdraw a matter that is already ongoing in court. Yes. Maybe upon, engaging in talks with the other parties. Save for cases that involve maybe defilement where courts will not allow parties to withdraw.
Okay.
Yes. Okay. So each justice system has its rules and its paths.
So, if I report someone, if I take someone to court, if I take someone to court and during the process I feel like it's too much, it's too much, it's too heavy, or it's draining. Yes. Let's just sort it out. Can I do that even if the case was ongoing?
Oh yes. Now sometimes, and this is not just in criminal matters, okay? Let's say you had an issue, maybe you had lent someone money, okay? And this person has refused to pay you and you've taken them to court. Yes. And you felt like you're getting tired of the litigation process and maybe it's taking long. Yeah. You can engage your advocates, or if you're self-representing yourselves, your advocates can, maybe say chat and go before courts and ask for time to be allowed to enter into what is known as a consent. Okay? So you go outside and you come up with a consent, and then you come to court and record that consent. Yes.
Okay. What happens when after a mediation process fails?
Yes.
What happens? If we've tried to talk to these two parties, they're not agreeing with each other, the terms are not favorable for either, or what happens?
Yes. Now back to mediation, which was our topic of the day. Should parties fail to agree in a mediation process? Again, I will give you the two scenarios where we have private mediation and where we have the court-annexed mediation. Should parties fail to agree where we are dealing with court annexed mediation, then the matter is referred back to court, as I had earlier stated, okay? And it continues with the litigation process. But should they agree, then that matter gets resolved, okay? In private mediation, if parties don't come to an agreement in resolving their issues in the mediation process, then they can decide to institute legal proceedings and maybe go the litigation way. And also, aside from litigation, we have other dispute resolution mechanisms as well. We have arbitration, we have negotiations, we have conciliations, among others.
Oh, okay.
Yes.
We will definitely do a show for each.
Yes.
Are lawyers or advocates needed during the mediation process?
So, even the mediators in a mediation process, their role is mainly to oversee, okay? When you're having a private mediation, okay, process, and maybe the parties insist that they want their advocates present, as an advocate, your role is mainly advisory in that process, okay? Because mediation is a process that allows the parties themselves to get involved in finding a solution for the dispute that they have at hand, okay? So as an advocate, your role mainly will be advisory. Yes. And for the mediator, it will be mostly to guide the parties through the process and to ensure that the rules of the mediation process are maintained.
So when we have lawyers, mostly we see this, that lawyers tell you, don't speak, and speak for you.
Yes.
Let me do this for you.
Yeah.
That does not apply.
In mediation, it's the parties that speak to each other.
What happens when you get yourself with a lawyer who does that?
No, because remember, the setup of a mediation process, we have the mediator, we have the parties, and let's assume that the parties decide to come with their advocates. Before any mediation process commences, rules of the mediation process are normally read out by the mediator. Okay? Even the advocates are aware of the rules. Okay? They know that their role is mainly advisory to their clients, and mostly this advisory role is normally given to the clients before commencement of the mediation process. Okay? The other role for the advocate is mostly to guide on the legalities, maybe of the solutions, should they find, should they reach an agreement. Okay? So you get that the rules are spelled out before the process begins, okay? Such that by the time the process is beginning, every party is aligned and they know how to go about the process.
Is it okay to have a mediation process without an advocate?
Oh, yes. In fact, in most cases, mediators normally advise that they deal with the parties, okay? Because remember also that mediation process, the process is a private process, okay? And some parties normally get there and they want to do the mediation without advocates, and others want their advocates present, okay? So it normally depends on also what is spelled out before the process begins, the understanding that is there among the parties, and the rules that have been spelled out. Yes.
Let us look at mediation now itself.
Yes.
When we compare mediation to litigation, or litigation, you can say it takes long because, you know, witnesses, you bring your witnesses, I bring my witnesses. But looking at the evidences presented to the court, the prosecution, the what, and all that. What makes the mediation process short? Is it that we'll just sit here and be like, so you do this, he does that, and it's over? Or what shortens mediation?
Okay. So you find that by the time parties are coming for the mediation process, each party has given their list of issues
Yeah.
that they're having. So you have your issues, this party has their issues. The mediator goes through the issues, okay? So you get that the first session is normally about introduction. It's an introductory session, okay? The parties get to know each other. If there are advocates that are involved, they also get to know each other in the process. The mediator also introduces themselves, okay? Then you also plan the sessions that you're going to have, okay? Then there is also the second session, mostly normally when the issues are now ironed out, okay? Then we have a session that is normally called the caucus session, okay? Where the mediator normally listens to individual parties on their own, okay? Before they converge again together, okay? So you get that the process is aligned, and that helps in shortening the entire time that is taken from the start to the end. Yes.
What if you were asked to choose between having a judge say, this is the way to go, and sitting down with someone and telling them, this is how I want things to go, which one would you advise us to take?
No, that is a tough one, because each party, each case is unique, okay? And each case comes with its own issues, okay? There are cases that are best sorted out in court. And there are cases that are best sorted out through mediation.
Okay.
I'll give you an example. Cases involving families. If you were to be asked, what would you recommend at the end of a dispute in a family setup? Every person would say they would love the family to still be in talking terms.
Yes.
Okay? Yes. Mediation offers that. It offers a platform for parties to still come together and talk. Because remember, the parties come up with the suggestions for their solutions. Okay? So it's on a case-to-case basis. Yes.
So it's if you are very passionate about the case and you want to really be involved or engaged in it, mediation is the best way to go, right? But playing the devil's advocate, what are some of the good things or the good sides to litigation?
Litigation is also good, okay? And litigation works best for individuals, so to say, because, for example, in commercial matters or in debt recovery, someone owes you. What you're looking for at the end of the day is for you to be paid what is owed to you.
Yes.
Okay? So in such a setup, if the other party, maybe you followed them for a very long time, and they're not paying you your money, they're not, you know, as agreed, then you'd rather just take them to the court process, because clearly that is not someone who wants to come and sit on the table with you and even offer you, like, you know, let's come up with terms on how I can pay you, or let's come up with a payment plan. That is someone who's clearly stating to you, you know, do what you want. So as I said, case-to-case basis, there are those that are best solved in court, and then there are those that are best solved through mediation.
Through mediation. All right, time has really been flying when we were sitting here. So what is your parting shot, your word of advice, or just to sum it up?
Parting shot. To every Kenyan out there and everyone watching this, do not shy away from mediation. Do not shy away from trying it out. It gives you the same results as those results that you would want from a court. Because at the end of the day, after you register you have your mediation agreement and you register it, you can choose to adopt it. Okay? So let's not shy away from mediation. And if you have a case that you want to solve in an amicable way, try mediation.
Try mediation.
Yes.
Try mediation. Where can, before we even go, sorry, I forgot to ask, where can one get mediators?
Wow, okay. So we have institutions, okay? I mentioned the Dispute Resolution Hub.
Yes.
Yeah, you can check them online. They aside from offering mentorship to mediators, they have a pool of mediators as well. Okay, that handle cases. So that's one place you can get mediators. We have FIDA. Okay, we have a lot of organizations, and aside from that, we also have law firms that have mediators. Okay, so mediators are
there.
They're many. They're there.
Let's mediate, guys. We do not have to take it the long way. I am on that. That has been a session worthwhile. Thank you very much, Wakili.
Thank you.
God bless you. And now we will try call you again for the other methods of solving disputes, the arbitration, the negotiation, all that. We'll call you back and we'll have that discussion. This has been Know Your Law. My name is Consolata Chibalonza. Thank you very much for keeping us company. Thank you very much for being with me from 9 p.m. It's past 10 p.m. I do hope you're going to have a beautiful and a wonderful night. Until next time, God bless.